All right. Well, good morning, everyone. My name is Melissa Olheiser. I'm the regional manager for the Fargo region of OECS. I'd like to welcome all of you to our Marijuana in the Workplace webinar. This morning, we have a special guest speaker, Tom Revnew. And Tom is an attorney who has represented employers in the labor and employment law matters throughout the nation for almost 30 years. So without further ado, I'm going to let Tom kick off this. A couple of things before I pass it over to Tom. We do have the chat feature working. If you have questions, please utilize the chat. I will monitor that. I will intercede and interact with Tom during the session if there's questions that are at that time relevant to ask. Otherwise, we might need to wait to the end so he can get through the whole presentation, because many of your questions might be answered during the presentation. So we'll kind of play that as we go. And then we will leave time at the end for Q&A. And if we don't get to everybody's, we always copy and save our chat. Those questions will then go to Tom and he can respond and follow up with you individually. So thank you again and welcome to our webinar on marijuana in the workplace. And I'll let Tom take over. Thank you.
Thank you, Melissa, and thank you, OECS, for having me speak today on marijuana in the workplace and the implications of potential legalization in Minnesota as well as elsewhere. And, frankly, I will say that in my lifetime, I never thought I would ever see the legalization of recreational marijuana. And I can remember when I was in undergrad, I would walk through the university, and we had a group that would sponsor an event every year on April 1st, and it was called Hash Bash, and it was run by the National Organization to Reform Marijuana Laws. And so at this point, it's probably 35 years ago, where they were pushing for the legalization of recreational marijuana. And I just remember walking through that area thinking, no way will this ever happen. And of course, we've seen it happen across the country, and we're now looking at Minnesota legalizing marijuana. And of course, it raises a whole host of issues, particularly safety issues in the workplace. And statistically, before I jump in, I wouldn't say there's a tremendous amount of data with regard to how the use of recreational marijuana has impacted safety in the workplace or elsewhere. Colorado, which was one of the first states to legalize recreational marijuana, there are some statistics out there where they have seen a 4% increase in automobile accidents and a 6% increase in fatalities as a result of an automobile accident as it relates to someone using marijuana. But that's the best industry data that I've seen thus far. Today, I'm going to talk, just give you a brief overview of the current and anticipated laws regarding marijuana, including what the current status of the bill is as it relates to legalizing marijuana in Minnesota. Of course, part of my practice over the last year has been handling questions from clients as it relates to employee use of the THC edibles and Minnesota's current laws as it relates to THC edibles. I'm going to touch on the Minnesota Drug and Alcohol Testing Statute, as well as touch on some other laws affecting drug testing. But let's just touch base first with regard to the current laws with regard to marijuana. And one thing that I thought would make sense to start off with is just touch base on the different types of terminology that's used for marijuana, THC, CBD, and hemp. And this slide does a good job of describing the different terms that we'll hear as it relates to marijuana. And of course, I'm here to talk about marijuana and cannabis, which is the psychoactive drug that we're concerned about. But of course, THC is the main psychoactive compound in cannabis, and it's also seen in Delta 8 and Delta 9 THC, which is used in the edibles. With regard to CBD, the cannabis oil, That's the non-psychoactive compound that's also found in cannabis that we're now seeing in many commercial products as well as dietary supplements. And certainly we see that in the drugstores every day. And then, of course, there's hemp, and hemp has lower concentrations of THC. And hemp is what is being allowed to use to create the edibles in Minnesota and produce the Delta 8 and the Delta 9 THC products. As we all know, when it comes to marijuana, marijuana still remains illegal under federal law. But what we've seen is a dramatic uptick in the states that have legalized marijuana. And of course, as it relates to Minnesota, we legalized, and so we currently have a medical marijuana law, which means that marijuana is available to individuals with certain medical conditions, which I'll talk about in Minnesota. And then we have other states that have legalized marijuana for recreational purposes as well. And just as alcohol is limited to individuals based upon their age, that's the same with regard to the legalized marijuana. It's generally you have to be 21 years or older in order to purchase recreational marijuana. And the laws will oftentimes limit the amount of marijuana somebody can use or the amount of THC somebody can possess. I thought this slide would be helpful just to see the number of states that have legalized marijuana. And this slide does a good job of showing you that there are quite a few states that have now legalized both recreational and medical use marijuana. And that's in the essentially the green, the states that are colored in green. And then you have states that there's no public cannabis accessible, whether it's recreational or medicinal. And as you can see from this slide, there's only really 3 states left that have not legalized marijuana in some form. And as we know, this is a recent phenomenon across the country. I would say that I started dealing with the medicinal recreational marijuana probably 10, 12 years ago, dealing with some of the issues with clients that have national operations and trying to address what do you do when somebody shows up with a medical card for marijuana, or what happens if you're dealing with the recreational marijuana. And each state is going to be different with regard to what you can and can't do if somebody tests positive for recreational marijuana or medicinal marijuana. And today I'm focused really on Minnesota because the vast majority of the attendees on today's program are from Minnesota. So to touch base on Minnesota's current marijuana laws. So in 2015, Minnesota adopted its medical cannabis program. And essentially that allows employees or individuals to use medicinal marijuana for certain conditions that are approved by the state. And some of the current ones include cancer, Alzheimer's, MS, ALS, autism, and there's a variety of other conditions that will qualify. And as you can see, in August of this year, OCD and IBS are added to the list of qualifying conditions in which individuals can use medicinal cannabis. And keep in mind that if you have individuals who are using medicinal marijuana, they may also qualify as individuals with a disability, where we have a requirement to accommodate those individuals under either the Americans with Disabilities Act or state or local disability employment laws. And then on top of the medicinal marijuana, last July, and this snuck through, and I've talked to a number of legislators and a number of lobbyists, and the Republicans, as the story goes, didn't realize that tucked into the omnibus bill was the legalization of edible cannabinoid products. So it snuck through and it passed. And as of July 1st of last year, Minnesotans age 21 or older can now purchase edibles and beverages containing THC. And under the statute, the products are limited to having 5 milligrams of THC per serving, and a package can't have more than 50 milligrams per package of THC. And of course, nothing under the statute limits how much of the products an individual can buy, nor does it limit how much an individual can eat or consume, I should say. And so, of course, employers have a lot of issues and concerns with regard to how that may impact safety in the workplace. Under the current law, the THC must be derived from hemp and not marijuana. And as I touched on earlier, the most common types of THC used in producing these products are the Delta 8 and the Delta 9. Now, one of the problems that has arisen with regard to the use of the THC edibles is right now, you can't determine whether somebody tests positive as a result of using the edibles or as a result of smoking the recreational marijuana. And of course, currently, there is no breathalyzer type test that's currently available for marijuana that would, in essence, tell us whether or not somebody is considered legally impaired or intoxicated. And so as a result, if you send somebody to a test, a drug test, and they come up positive for the use of marijuana, currently we can't tell whether somebody was under the influence of marijuana at the time of the test. And in addition, we can't tell whether or not somebody was using the edibles or whether they were actually smoking recreational marijuana illegally. And I'll talk about some of the issues that come up as a result of the edibles, but it's problematic because employers risk unlawfully terminating somebody as a result of a positive test for marijuana. So with regard to legalization of recreational marijuana in Minnesota, I firmly believe it's all but a foregone conclusion that it will happen. Having discussions with some lobbyists over the last week, some think maybe it won't happen this legislative session. So there's a glimmer of hope. Most would say it's going to pass this session, but there are some things going on at the state capitol right now that, perhaps it won't happen. I'm predicting it will. Some may disagree with me, but in essence, if it does pass, the question is, when is it going to take effect? Typically, the bills and the laws will take effect as of July 1st. There may be a delay here when the bill is actually passed, but there's some interesting things in the 300-page bill that's not being talked about in the media. And I'd like to point out some of these just because, as you know, sometimes bills, there's features that are built in for certain segments of the population. And I have three things that are of interest. And one is with regard to the businesses that will ultimately be licensed to sell marijuana, they will be permitted to have quality control testers working for them. And essentially what that means is that an employee working for the cannabis business can sample cannabis up to 3 times in a 24-hour period, as long as they don't interact with customers for three hours afterwards. So that you can quality test the marijuana if you work there. 2 is if you are a business that wants to sell marijuana, in order to get your license to sell the marijuana, you're going to have to enter into what's referred to as a labor peace agreement with a union. And I figured if you were selling marijuana, you probably already had labor peace, but you're going to have a relationship with a union on top of that. And in essence, I believe that this is where the legislature is essentially saying you're going to have a collective bargaining agreement with the union if you want to sell marijuana. Employees who work for the business selling the marijuana. They can't show up under the influence of marijuana, but as I said, they can engage in quality control up to 3 times while working there. Additionally, under this bill, the bill will essentially make cannabis protected under Minnesota's lawful consumable product statute, which I'll talk about in the future here, but essentially it means that you can't take an adverse action against somebody as a result of using marijuana. As I said before, I think the legislature is going to pass this bill. They're still considering it. One common question that is raised by employers and businesses oftentimes entails, hey, I'm an employer that employs over the road drivers. They have CDLs and we're regulated by the Federal Highway Administration. Will this change what we do? And the answer is no. The state legislation will not alter federal laws on testing marijuana. So if you are an employer with DOT covered drivers, you will continue to conduct your drug and alcohol testing as you normally would for employees who are covered under those laws. So with regard to the bill, as I said, there's 300 pages in that bill addressing a whole host of issues, and things are moving around in the state capitol with regard to what the bill means. But for those of you that are in attendance today, I believe that perhaps what is most important to you is, what does it mean for us as businesses? And in particular, what does it mean for us if we have a drug and alcohol testing policy? And what can we do and what can't we do? And again, I want to emphasize that this is a bill right now. It has not been passed. But if it is passed, essentially what the current bill provides, and I looked at this as of 2 days ago. So the bill is, this is the most current version of the bill. I don't think it's going to change much. It would essentially prohibit employers from testing job applicants for the purpose of determining whether they have the presence of marijuana in their system at the time of the pre-employment test. Additionally, it would prohibit employers from refusing to hire someone if they refuse to take a test that tests for marijuana, unless you're a contractor or a business that falls under a federal or state law that mandates that you conduct drug and alcohol testing for marijuana. It will also prohibit the arbitrary and the random testing of employees for the use of cannabis. Now, under the bill as it's written, it essentially provides that you as an employer could test somebody if they're using marijuana if you have reasonable suspicion that the person working or on your premises meets certain criteria. And one of those criteria would be that the employee does not possess the clearness of intellect and control of self. Now, I kind of scratched my head because I think we'd all say that there are times where a lot of our employees do not have the clearness of intellect and control of self, but that doesn't necessarily mean that they're using marijuana. Additionally, the way the bill is written, you could test if an individual has violated your work rules with regard to having the possession, the use, impairment, sale, or transfer of cannabis while working for the company. And if they have sustained a personal injury or they've caused a work-related injury, you could also conduct the drug testing for the use of marijuana. Now, I think one of the big concerns that employers have had with regard to the legalization of recreational marijuana, and in particularly the construction industry, but also in any position where an individual performs safety sensitive tests. And that is, well, we're concerned, we want to keep our employees safe. Are we going to be precluded from testing our employees particularly those who are employed in a safety sensitive position. The way the current bill is written, cannabis testing, so testing for the use of marijuana, could occur in certain jobs. And right now, the way the bill is written is that those who are performing in a safety sensitive position could be tested. They have also addressed situations involving peace officers, firefighters, individuals that care for children, vulnerable adults, or who care for patients in the healthcare setting. And they've also addressed CDL drivers. All of those are scenarios where under the current bill, you would be able to continue to conduct testing of individuals for the use of marijuana. And then, of course, if you're required to conduct drug and alcohol testing as a result of a federal grant or as a result of a state law, you could also continue the testing as required by the receipt of those grants or as required by the federal or state laws that you fall under. Again, this is a very high level overview of what the current bill provides. And there's a lot of detail in there. I'm going to cover some of these items, but I wanted to address some of the concerns that I hear from clients with regard to, hey, what is this law or what does this bill provide as far as what we can and can't do with regard to testing? Now, keep in mind, I know a number of you that are in the audience, you operate in multiple states. And as a result of operating in multiple states, hopefully you're well aware that quite a few states have their own state laws that deal with what an employer can and can't do with regard to drug and alcohol testing, or they have certain programs as it relates to the drug and alcohol testing. And so this slide sets forth all the various states that have some provisions built into the statutes as it relates to what an employer can and can't do with regard to drug and alcohol testing, or they have statutes addressing drug and alcohol testing in the workplace. My experience, because I've worked with employers across the country, I will tell you that I believe that Minnesota has one of the most restrictive, if not the most restrictive statute with regard to what employers can and can't do with regard to drug and alcohol testing in the workplace. I would suggest that if you're using a Minnesota policy and following the protocols under your Minnesota drug and alcohol testing policy, there's probably a good chance that you're in compliance with what these other states require. But having said that, you should still have your policies reviewed to make sure that you're compliant in all the states that you're operating, because there are nuances with each and every state as far as what you can and can't do for drug and alcohol testing. As far as if you are conducting drug testing policies, things that I'd like to point out are that if you're in Minnesota, as I said, Minnesota has a very restrictive state law with regard to what employers can do with regard to drug testing. And first and foremost is in Minnesota, you cannot conduct drug and alcohol testing without having a written drug testing policy that contains minimum provisions. A common mistake that I find from employers is they have in their employee handbook a statement that says, we will conduct drug testing for reasonable suspicion, period, and that's it, or something to that effect. And I will tell you that is non-compliant with Minnesota's drug testing statute. And if you have that, and that's what you're relying upon to test employees, you will be violating the law. And if you terminate somebody as a result of a defective drug testing policy, you open yourself up for a wrongful discharge claim. And I've had a number of those types of cases during the course of my career. So keep in mind that in Minnesota, if you're going to do drug and alcohol testing, the policy has to meet minimum criteria. which means you have to describe who's going to be subject to the testing as far as employees and job applicants, under what circumstances the testing will take place, such as pre-employment, post-accident, reasonable suspicion, what have you. The policy has to set forth the right of an employer or job applicant to refuse to undergo drug and alcohol testing and what the consequences are of such refusal. It also needs to set forth what potential actions will take place if somebody tests positive based upon a confirmatory test. And additionally, the right of the employer or the job applicant to explain a positive test on a confirmatory retest, as well as to request and pay for another confirmatory retest, as well as any other appeal procedures that may be available under the drug and alcohol testing policy. And that's in a very, very high level of what your policy needs to have at minimum. Additionally, under the statute, and this is where I see employers oftentimes make mistakes, is they don't provide employees or the job applicant of written notice of its drug testing policy before any drug testing actually takes place, as well as oftentimes employers fail to post a notice of its drug testing policy in an appropriate and conspicuous location on the employer's premises. So in other words, you should have posted on your bulletin boards something that gives employees and job applicants a notice that you do have a drug testing policy and that they can ask for copies of that policy during regular business hours. Goes without saying, and your laboratories will work with this or work with you on this, but prior to requesting a drug test, the employee must also sign an acknowledgement form that they've seen your drug testing policy. So when we start digging into, what the policy should include, it should include a section on that you actually prohibit drug use and activities, and that prohibited use could be that you're prohibiting the consumption, possession, use, or solicitation of an illegal controlled substance or a legal substance being used or possessed legally. And I'll note that subject to changes in the law, i.e. referring to the recreational marijuana bill that's pending, you should have a statement that refusing to submit to a test would constitute a violation of the controlled substance policy and could be treated as a resignation of employment. Again, I put in bold red, subject to changes in the law, because essentially the bill that's pending right now prohibits employers from taking an adverse action against an individual who refuses to test for marijuana. So some of the things as far as when you would, the types of testing that you could conduct, as I said, you should describe what those scenarios would be. So pre-employment obviously should be for somebody to undergo drug testing after a conditional offer has been made. So if you're issuing an offer of employment, that offer of employment should be conditioned on the employee submitting to the test, as well as the employee taking and passing the test. Oftentimes employers will have a post-accident testing provision built in to their drug testing policy. I think most employers do. And your policy should describe what type of post-accident scenarios will lead to a drug test. And so it could be a serious personal injury, significant property damage, a serious moving violation, serious safety violation, and you can put more detail into that. So a significant property damage could be defined as damage over $500. What I'd like to point out with regard to post-accident testing is somebody you may recall that when President Obama was in office, the Federal Occupational Safety and Health Administration was limiting employer's ability to conduct post-accident testing without an individual inquiry as to, whether or not there's reasonable suspicion that the accident was caused as a result of the individual's conduct. Under President Trump, that restriction was limited. I haven't seen any movement under the Biden administration to go back to try to limit post-accident drug and alcohol testing, but it's something for you to keep your eye on if you are doing post-accident testing. If you're going to do random testing, and in particular, if you're doing random testing in Minnesota, it has to be limited to employees who are performing safety sensitive functions, and that's it. And essentially a safety sensitive position, you want to define what those roles are, but it's essentially somebody whose duties or their functions would lead to threatening the safety or health of another person if they're impaired. With regard to random testing, a common scenario comes up where employers just want to say, well, I'm going to pull whoever I want at any given time, and that's random testing. And really, random testing means that all employees have an equal chance of being selected each time. And if they are selected for random testing, your policy should indicate that they're required to report to the testing site immediately upon selection and notification. Another scenario where employers do their reasonable suspicion testing, or they do reasonable suspicion testing, and that's where you have made observations that somebody is under the influence of drugs and alcohol, and that's when you would do the testing. I will tell you that if you do reasonable suspicion testing, you should be conducting reasonable suspicion training so that your supervisors and managers are trained on what are the criteria that show that somebody is actually under the influence of drugs and alcohol. And oftentimes, and the policy that we put together for employers has a checklist that supervisors can use that will identify some of the common symptoms for various drugs or for alcohol, whether it's the bloodshot eyes or the staggering or the stuttering or what have you. But if you're doing reasonable suspicion testing, train your supervisors and your managers, have forms that you use to complete that really identify that the person is in fact under the influence of a controlled substance. Now, with regard to Minnesota law, as many of you know, under Minnesota law, if somebody tests positive and it's their first positive test for you, you have a duty as an employer to offer that individual the opportunity to go through rehabilitation. And if they refuse to go through rehabilitation, then you take appropriate action against them. But under Minnesota law, first positive test means that you have to offer them an opportunity to go through rehabilitation. And oftentimes, as part of the rehabilitation, employers will build in to the rehabilitation program, particularly for employees that have to go for treatment, that before they return to work, they need to undergo a return to duty test. And so if you're doing that, that should be built into your drug and alcohol testing policy. And secondly, employers often do follow-up testing as a result of somebody who's returning to work. And that follow-up testing, you should describe that in your policy as to how often you'll do the follow-up testing. And under state law, you can do unannounced follow-up control testing for up to 2 years following an employee's completion of a rehabilitation program. Other things to think about really across the board, not just in Minnesota, in other states as well, but your policy should outline the procedures that you'll use to conduct a drug testing. or conduct a drug and alcohol test. But importantly, Minnesota law and those states that really regulate drug testing in the workplace require that employers follow certain protocols. And that means that you got to have a strict chain of custody procedure to ensure that the employee specimen is not tampered with. Oftentimes you have to use a state or federally certified laboratory. And those procedures oftentimes require that you confirm the initial positive drug screen on a second analysis, as well as an initial positive alcohol screen on a second analysis. You should be working with your laboratories to make sure that they are following the protocols required under the state laws in which you're operating. And then finally, the policy should outline which drugs will be tested for. You'll see that I highlighted marijuana in red. I'm going to talk about that here momentarily because I get a lot of questions from employers with regard to, should I just drop testing of marijuana at this point? Everybody that shows up for a employment test, they're testing positive, or, we're not going to have enough employees if we test for marijuana. And I'll touch on that here momentarily. But like I said, just getting back into the policy with regard to once an individual undergoes testing, as an employer under Minnesota law, you have to provide the employee with the results of the test within 3 working days, whether it's an applicant or an employee. And if they have tested positive, you have to give them the right to explain the positive test or the reliability of the testing. Additionally, you have to give them notice that they have the right to request a confirmatory retest or request a copy of the test result. Now, one question that's often raised by employers is, don't they already have that ability to explain the positive test to the medical review officer? And the answer is yes, they do. The medical review officer should be screening the tests first before they report a positive test, but the employee gets a second chance of explaining the positive test. And some of you in the audience may also know that MROs, they won't screen an individual employee who says, hey, I've been using the edibles, and that's why I tested positive for marijuana. The positive test will still be reported to you. The labs are not distinguishing between a positive test for the use of the edibles versus the use of recreational marijuana. And I'll talk about that momentarily. But if an employee tests positive for drugs or alcohol, you can withdraw an applicant's conditional offer of employment. As I said, if somebody tests positive and they're an employee, you have limitations on the first positive test. And those limitations on the first positive test in Minnesota are essentially you have to give them a chance to participate in a rehabilitation program. The employee is responsible for the cost of that program unless your insurance covers that. Other restrictions on drug testing. Also keep in mind that if somebody is in the registry for medicinal marijuana, you cannot take adverse action against them. So the medicinal marijuana individuals that are in the registry are in fact protected from an adverse action as a result of a positive test. Goes without saying, and my experience is most employers are good at this, but positive test results are considered medical records, and those documents should be treated as confidential, and those test results should be contained in the employee's medical file, not their personnel file, to ensure confidentiality. And to be abundantly clear, the marijuana bill that is pending is making it very clear that drug tests are confidential documents that should be maintained separate from the personnel file. So jumping back into some of the other laws that affect drug testing, one of the big issues that employers have been dealing with are not only the medicinal marijuana, but also the THC edibles. And as you can see in this slide, when the law first passed, there were 800, roughly 800 employees that enrolled in the medical cannabis registry. And not surprisingly, 7 years later, we have almost 40,000 Minnesotans that are enrolled in medicinal cannabis. And so I can tell you that I'm getting an increasingly number of calls from clients with regard to what do I do and can I take adverse action? Or somebody just tested positive and they just told me that they're part of the registry. Can I do anything with them as a result of the positive test? And the answer is no. And then, of course, you have individuals who are testing positive because now that the THC containing edibles are available, you're seeing a lot of individuals that are experimenting with the THC gummies. And of course, employees or the general public will walk into a liquor store. They walk into the liquor store and they buy, their liquor, and right at the front desk, there's the THC gummies. Well, gee, I might as well try this as well. And if you have a drug testing policy and they test positive, well, that raises a whole issue with regard to, can you take action against them as a result of testing positive? Under the marijuana legalization bill that is pending, it would add cannabis to Minnesota's lawful consumable product statute, and it would make it abundantly clear that you cannot take adverse action against somebody as a result of using either recreational marijuana or the THC containing edibles. So what does that mean? So Minnesota has this law that essentially says you cannot discharge or discipline employees for using a lawful consumable product. Under the current state law, a lawful consumable product is defined as a product whose use or enjoyment is lawful and which is consumed for use and enjoyment, and it includes food, alcoholic, and non-alcoholic beverages and tobacco. And that is the current statute as it's written. So you don't see marijuana written, you don't see the CBD edibles written into this statute. I'm going to talk about that in a moment, but so generally speaking, you can't take adverse action against an individual because they like to eat pizza. You can't take adverse action against somebody because they like to have an occasional beer or because they smoke. That would be unlawful. There are certain exceptions to the lawful consumable product statute. And, the best example I can give you is if you're the American Lung Association and somebody smokes, well, obviously when your mission is to eliminate smoking, the American Lung Association would have a good reason to say, hey, we're not going to employ somebody who smokes. If you have an employer that, they're a clinic that they're trying to prohibit individuals or trying to train or educate employees or train the general public on, rehabilitate them on a substance abuse issue, that clinic may have a good reason not to, employ somebody that uses a CBD edibles. That's an open question, but those are some of the areas where there are exceptions to this statute. My general belief is that the edible cannabinoid products are likely protected and you can't take an adverse action against somebody for using the lawful consumable products. So arguments that it's currently not protected. Well, last year in 2021, the state legislature tried to include cannabis into the lawful consumable product statute, and they failed to do so. So we are seeing that in this session, they're trying to include a provision, and they will ultimately pass a law that does include cannabis in the lawful consumable product statute. So under current law, I think it is a protected consumable product if they're using the THC edibles. And I think the risk of taking adverse action are severe. So if you take adverse action against somebody for using the edibles, and you terminate them as a result of using the edibles, you're going to face a wrongful discharge case, and the employees would be entitled to the lost wages and benefits incurred as a result of the employer violating the law. And in addition, they would be entitled to their attorney fees and costs. Questions that are raised is, okay, I understand I face the risk of, if I terminate somebody for using these edibles, but can I prohibit them from possessing the edibles while on site, while working for the company? And the answer is yes. You can treat the edibles just like you would treat alcohol, right? You're not going to allow employees to have, a liquor bottle on premise, or you're not going to allow them to have, a case of beer on premise. You could do the same thing with the edibles. So with regard to drug testing of the edibles, questions are raised a lot by employers with regard to, gee, can I still do reasonable suspicion testing? Should I do pre-employment random post-accident testing for marijuana, particularly when we're seeing an uptick in positive tests? And what I would say is that with regard to reasonable suspicion testing, if you have trained your managers and your supervisors, and you are actually identifying that somebody is under the influence of drugs, certainly you can send them for a test. And certainly I think you would have a good argument that if they test positive for marijuana, and then they later claim, well, gee, I was using the CBD, I was using or not the CBD, but the edibles, I think you'd have a good argument that the positive test was as a result of them being under the influence of marijuana because of the observations that have been documented. And therefore, you could take action against them, whether it's if it's a first positive, sending them to rehabilitation or termination. Now, oftentimes what employers don't understand is if you do have reasonable suspicion, you may not want to send them for a test. If they show up and they're under the influence, and it's very clear that they're under the influence, they're staggering and what have you, you may dispense of the testing altogether because it's so evident that they're under the influence, or they admit that they're under the influence. There's really no need to send them for the test. And if you don't send them for the test, they don't fall under the protections of the drug and alcohol testing in the workplace statute, meaning you could take adverse action against them just based upon them showing up under the influence. Also, questions are raised, well, gee, what should I do with regard to pre-employment, with regard to random and post-accident testing as it relates to marijuana? And I will say that what I have seen is a significant uptick of employers who have just made a business decision. We're not going to test for marijuana for pre-employment, because if we test for marijuana pre-employment, we're just not going to get applicants to apply. And that's a business decision that you'll have to make. But I have seen quite a few employers that have just said, pre-employment, we're not testing for marijuana. Of course, you still have to test for marijuana if you fall under a state or federal law that requires it. With regard to random and post-accident testing, you can still conduct marijuana testing, but keep in mind that you still face significant risk under the law, because if the employee tests positive and they come back and they say, gee, I tested positive because I was using the edibles, in that scenario, it would be considered protected. And if you take action against them, you fall under a potential wrongful discharge claim. And like I said at the very inception, it's really impossible right now with the drug tests that are out there to determine whether or not an employee is ingesting the THC legally or illegally. I'm optimistic that that technology is coming, and it's coming in the near future. But right now we don't have that technology. The final comments are, as I've said on a number of occasions, the federal laws affecting drug and alcohol testing remain. So if you fall under the federal highway drug and alcohol testing protocols, those rules remain intact, and you can terminate employees for violating the DOT drug and alcohol testing rules. And of course, there are other federal laws that mandate employers conduct drug and alcohol testing beyond DOT, but all of those remain intact. So Mike, as far as closing remarks, we're entering uncharted waters in Minnesota with regard to recreational marijuana and the use of recreational marijuana. I believe it's an all but foregone conclusion that we are going to have recreational marijuana this year. I think it is critical that businesses and their leadership start discussing how they're going to address this with their drug and alcohol testing policies. Maybe it's also addressing providing education to employees as to what it means to use or abuse drugs and alcohol, including marijuana. It also includes providing training to your employees with regard to the reasonable suspicions and how managers and supervisors can identify that somebody is in fact under the influence of drugs and alcohol, and in particular marijuana. And I had indicated that we would, and Melissa indicated that I'd leave a little bit of time for some questions and answers. And Melissa, I'm going to turn it over to you.
Okay, thank you, Tom. I'm going to start as they rolled in. I waited. Some of them I think have been answered, but let's go back to the beginning. I have a question that says, as a treatment center, we currently prevent staff from bringing drugs and alcohol on site. How should we accommodate this with medical marijuana license or for recreational use?
Yeah, so with regard to both medicinal and ultimately recreational, you can still prohibit them from bringing that on site. So they're not permitted to use while working for you, while we're on working time. And so I would not change your policies at this point in time.
Great. There was a question about random drug testing, but you had a couple slides that covered that. Is there a possibility to get a list in layman's terms of Minnesota restrictions with ER drug testing and what the company can and cannot do? Is that something you can share with us and we can send out, or do you have a quick answer?
Well, I think the question was, what is the testing that you can do in Minnesota on a drug and alcohol testing policy? And that's what I was laying out in my slides with regard to what's required to be in a policy and when you can conduct the drug and alcohol testing. So I'm not sure.
I have the individual, you and I can also send her a message for more information. There's a question about, is there a form template for policies that could be provided, or how could someone get a template as a starting point?
Yeah, I mean, as far as a template for a drug and alcohol testing policy, well, I mean, I can tell you that we draft drug and alcohol testing policies for our clients for a fee. I don't like to provide a template just because it can lead to some fairly serious consequences if employers don't do things right. And oftentimes they need to understand what's required of them when they do enter into the realm of drug and alcohol testing. And, I will throw this out just because the question has been raised. I know oftentimes laboratories will also provide a sample policy, but if they do, I certainly recommend that you have it reviewed by your legal counsel.
Thank you. There's a question, what can a company do about employees smoking pot on company premises?
Yeah, it's still unlawful, and it would be unlawful as the bill is currently written. So if they're smoking marijuana and you have a policy that prohibits the use of smoking marijuana, obviously I would make sure that you're doing your due diligence and you're doing an investigation and you have the evidence that the person was actually observed, or maybe you have photographs of the person using the marijuana, and assuming that you can establish that they were, you could take appropriate action.
Perfect. What if the corporate office is in Minnesota and they have a plant in another state? Do we go by the corporate state law or the state the plant is actually in?
Yeah, so if you are based in Minnesota, but let's say that you have a Montana facility, I would apply the Montana law to the employees that are working at the Montana facility. If you have individuals that are traveling back and forth, but they're Minnesota based, they would fall under the Minnesota policy. As a general comment. I mean, obviously I need to know more, but that's high level.
Okay. There's another one that says, you mentioned you can't take adverse action against someone in the registry for medical marijuana. We are a transportation company and we have been told that we cannot distinguish between the two and cannot hire someone regardless if it is prescribed or not.
Yeah, that's a great follow-up question. And the comment that I made was pretty broad as summarized in the question. And to be clear, the attendee indicates that they're a transportation company. So I assume that they fall under the DOT drug and alcohol testing statutes and rules. And if that is the case, the individual is not protected under federal law. And so the medicinal marijuana is not protected as it relates to employers that fall under the federal statutes.
Okay. I think you might have covered this, but I'll ask anyway. Are edibles protected under DOT drug testing?
Yeah, great question.
Yeah.
I would say it's not, because it's showing that somebody tested positive for THC. And so if the individual is a DOT covered driver and they test positive, I would apply the DOT rules.
Okay. I'll ask a couple more, but I'm also watching the time because I know that we want to follow up and give your information here at the end as well. Can you speak to which laws are required to be followed by a North Dakota company doing work on a construction site in Minnesota?
Great question. And if your employees are working in Minnesota, you should apply Minnesota law.
Okay. The law says you can't terminate on a first offense, but can put your company in your company policy that they can be terminated on a first offense if they cause a death, serious injury to self or others, or cause a significant amount of damage to property. Not sure the question.
Yeah, I'm not sure.
We might have to reach out to her.
Yeah,
There's a lot of questions in the chat. We have 2 minutes left, and I do very much want to respect everybody's time. So what we'll do is we'll copy the chat. Tom and I will get together and I will share the information with him, and we can follow up directly, the ones we haven't got to. There's just so many questions coming in. So, Tom, do you want to go to the next couple slides? As everyone has probably saw when we advertised this webinar, it was approved for a continuing education credit. So if you do need this, we sometimes have you put the information in the chat, but this time we'd like you to take a screenshot or write down. If you would please email Jennifer at oecscomply.com. If you need the CE, she will send you the evaluation that has to be completed. Once you return that back to her, she will send you the certificate of completion. This is the process that is outlined by the Midwest Center of Occupational Health and Safety through the University of Minnesota. We don't have an option to do it any other way. This is how it's tracked. And then we also have to keep track of everybody that we issue a CE to. If there's questions, please reach out to Jennifer at oecscomply.com, or you can certainly reach out to myself and I can get that information to her. The next slide, please. So we're gonna, Justine, can you start the poll? We'd like to get some feedback, how you liked this webinar. I'll let it go here for just a few more seconds, because your feedback is very important to us. Justin, you can end the poll. We appreciate everything. We take the feedback seriously because we want to continue to provide great and useful webinar and content to our clients and anyone else that's attending this webinar. And then Tom, do you want to share your information?
Yeah. That slide just froze for a moment. There we
Oh,
go.
that's okay.
Yeah.
It happens sometimes.
And if you do have a follow-up question, I do like to note that if you attended today's webinar and you have a follow-up question, please feel free to follow up with me. Shoot me an email, give me a call. Let me know you attended this webinar and I'll courtesy our initial discussion. So otherwise, thank you.
Yeah, thank you, Tom. And thanks to everyone for attending. I'll leave the chat up here for just a little bit yet. And then we'll copy that and make sure that we follow up with everyone that we didn't get to their questions. So I hope everyone has a wonderful rest of your day. And thank you again for attending our webinar. Thank you.